Was there a violation of Bryan Kohberger's due process rights by the court stopping their survey? Things are getting a little nasty between the lawyers in the Delphi case. The Arizona legislature moves to help George Kelly by changing the law, but is that an admission that the current law doesn't really cover the facts in his case? Guess where Jennifer Crumbly wants to stay if she doesn't get sentenced to prison? You'll never guess. And should the prosecutors across the country continue to have complete immunity? Well, the Supreme Court may weigh in on that. A National Guardsman runs from a police checkpoint. Why do you think he was running? And then our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And remember, you can also listen to us anytime on any of your favorite podcasting apps. And guess what? We are almost at 2 million podcast downloads. You may think, well, that's no big deal. People like Joe Rogan get that in a day. That's right, Joe Rogan does. But 99.9% of podcasts get about the, 6 downloads. Think I'm joking? Look it up. Anyway, so thank everybody for watching. Now, you may say, hey, Scott, is that a Band-Aid on your face? Yes, it is. Why? Are you okay? Yes, I am. It's that annual or biannual 6-month checkup for the dermatologist to look and see if I've got any more concerning little precancerous spots all over my body. Yes, it never gets old. Yes, it does. Anyway, we're going to be fine. So if I got to keep the Band-Aid here for a day or two, or my face is peeling because they did all the freezing on my face, now you know what it's all about. All right, let's go ahead and open the record for April 4th, 2024. And first on the docket, we just brought to you, and you can watch the hearing in its entirety, the hearing in the case of Bryan Kohberger versus the state of Idaho. What was the issue? Well, this was kind of the emergency hearing because the prosecution filed last week a motion on Friday, and the judge granted it before the defense could respond. And then the defense responded by saying, Judge, prosecutors, you're violating Mr. Kohberger's rights, and you cannot stop us from doing what we're doing. Well, what were they doing? The defense was preparing a survey through a professional to go out and ask questions to see if the potential jury pool in Latah County has been so overwhelmed and potentially biased as potential jurors against Mr. Kohberger that he cannot receive a fair trial. These type of surveys are done in a high-profile case. It is quite common. What is the big hissy fit about? Well, nobody apologized. Well, a little bit. Everybody overreacted. The prosecutor overreacted, the judge overreacted, and the defense probably overreacted as well. How did the prosecution overreact? Well, they went to the judge and said, this is a terrible, they're violating the court's dissemination order about information related to the Bryan Kohberger case. Shut it down, shut it down. The judge didn't have a stipulation. He didn't know what to do, so he said, fine, stop it. The defense was like, hey, it's Friday afternoon. I'll file my response on the following Monday. And Judge, why are you violating Mr. Kohberger's rights? Because, normally in the legal process, one side files a motion, the other side gets to file a response, the other side gets to file a reply, and we have a hearing. Why are you granting an ex parte order, basically, or an ex parte motion without hearing from the other side? We don't really like that in the legal system. Only in very rare circumstances does the court do something ex parte. So anyway, the prosecution kind of backed off their motion a little bit, saying that they weren't saying there were ethical violations. They just didn't like the questions that were being asked. They conceded the defense has a right to do the survey. They didn't like the questions being asked and said, we're worried about it tainting Mr. Kohberger because some of the questions that were asked are not truthful information as it relates to this case. Oh, why is that? Well, because everything has been so hidden in this case that a lot of the news media and people on YouTube, etc., come up with stuff that is not true, and it gets reported. all the questions in the survey came from news media articles. And the fact that it's out there, whether true or not, is potentially tainting the jury pool. The judge basically said, I probably shouldn't have done it, but what was I to do? I'm positive I didn't violate Mr. Kohberger's rights, but, let's have more hearings more frequently so that we can resolve these issues, and let's do what we can do so we don't have to start all over again and spend a lot of the taxpayers' money on this particular case. So the expert who is coordinating and running the survey, a Dr. Edelman, will appear at a hearing in a couple of weeks, and they'll decide what's going to take place, and they're doing surveys in other jurisdictions. Sounds like the judge wants to hold off and see what takes place as it relates to some of the questions. I don't think the judge gets to ask what or approve the questions they get asked. So the judge kind of apologized as well for him overreacting. The defense basically said, well, maybe, I understand, Judge, it was a Friday afternoon, whatever, but you shouldn't have done it, and, well, it's already done. And so maybe I overreacted by saying you're violating Mr. Kohberger's due process rights. Everybody backed off. But that's what happens when you don't get all of the information. People reacting with not all the information, well, creates people sometimes looking silly and putting their foot in their mouth. And that's kind of what happened today. Nothing really is taking place other than they're going to have a hearing. So it was a hearing to schedule a hearing, but I think I summed it up for you quite accurately. Next on the docket, the things are heating up in the Delphi case, all right? And you may say, Scott, what is going on in Delphi that hasn't already taken place already? Well, first, the courts issued, and I saw a little blurb about this the other day, but a viewer sent this to me as well, and it's the actual emails. The court issued an order saying, hey, I've received all these emails from concerned citizens about not having cameras in the courtroom, so I am going to make an order that these be sent to all of the counsel involved, and here they are. Just to give you a couple of them, Judge Gull, I am writing to relay my concern with your order for no media coverage in the Richard Allen case. The community, and I am not only talking about Delphi, it is a nationwide community, deserves to be a part of the trial. What are your reasons? Will you please reconsider? Another person says, Judge Gull, I'm writing to express my concerns regarding the Delphi, Indiana trial and the critical need for transparency throughout the legal proceedings. As a concerned citizen and a former paid advocate for the company I reside in, I firmly believe that transparency is essential to ensuring justice is served and maintaining public trust in the judicial system. The tragic events surrounding the murder of Abby Williams and Libby German in Delphi have deeply affected the community and garnered nationwide, worldwide attention. However, the lack of transparency surrounding the trial proceedings has left many unanswered questions and fueled speculation. It is imperative that the court and law enforcement agencies involved in this case prioritize transparency to provide clarity to the public and foster trust in the judicial process. This includes providing timely updates on the progress of the trial, disclosing relevant evidence, and ensuring that the proceedings are conducted in an open and fair manner. Well, most of the emails that were sent to the court were quite polite. There was only one that maybe somebody should have maybe taken a moment before they hit the send button. But, hey, what can you do, I guess? Anyway, they all urged the court to televise the proceedings for full transparency. Just kind of like what I say. That's right, transparency. It's a good thing for the government to be transparent. Well, and when I say things are heating up in the Delphi matter, the state responded to the defense third motion for a Franks hearing. The Franks hearing is basically saying that there were material misrepresentations or omissions from the affidavit for various search warrants, and therefore they are invalid. Now, the state in this particular case, it oftentimes actually calls the defense liars. Okay. And I understand these guys don't like each other. The prosecutors in the Delphi case and the defense attorneys, and the judge doesn't like the defense either. But I'm telling you, you go to most courtrooms, the judge is going to admonish you if you start calling the other side liars. You have to be a little more eloquent when you do that. So instead of saying they just outright lie, you need to say things as it relates to, oh, they speak with forked tongue. I'm concerned as to the statements that have been made. I'm very concerned. I think there may be some ethical considerations that need to be considered here. That's how you get around calling somebody a liar. And that's what the prosecution is doing in their particular response. It says the defense outright lied in their motion and misrepresented the true findings of Professor Turco. Lieutenant Holman reported the truth, and his statements that Turco's findings were inconclusive was correct. The defense's statements that Lieutenant Holman somehow was misleading in his report is entirely false. When they start calling each other liars, ladies and gentlemen, you know things are going to get ugly. We may have a fisticuff. Maybe that's why Judge Francis Seagal doesn't want this case televised, because it's going to literally be one of those situations where we showed up to watch a trial and a fight broke out. Getting interesting, ladies and gentlemen. And I do hope the judge reconsiders and allows cameras in the courtroom for full transparency. Hey, let's face it. If the evidence is there and it's overwhelming and the government meets their case beyond a reasonable doubt, or meets their burden, find them guilty. That's the way the system works. Let's have the truth. Let's see. And the truth is legal and competent evidence that comes in at trial, not what somebody speculates it will be. Legal and competent evidence admissible under the rules of evidence. That's what matters. Let us see it. Next, the Arizona legislature is trying to change the law in an effort to help former rancher George Kelly. But is it an admission that the facts may not necessarily be on his side? Oh, I don't know. So there is a bill advancing in the Arizona legislature that says a property owner would be able to kill or threaten to kill people who cross their property to illegal entry into the United States. Now, although the bill does not mention immigrants, the sponsor, a Representative Justin Heap, said in a committee hearing that his bill was intended to close a loophole to assist ranchers who may witness someone trespassing on any section of their land, not just within a mile of their home. Now, the bill would modify the state's existing castle doctrine, which we've talked about, right? You have a right to protect your property, which allows home and property owners to threaten or use deadly force to stop someone from criminally trespassing into or on their property. They can use deadly force only to defend themselves or another person. Now, the law considers property to be structures for residency, occupied or not. Now, the proposal, as you can imagine, has a little bit of opposition, where some people are saying the hardline immigration laws have galvanized opponents, particularly Latinos, to beat back the laws and help erode the Republican grip in the state. So, like I said, this comes as the Arizona rancher George Kelly faces trial on second-degree murder charges for the January 2023 shooting death of Gabriel Butime, who had entered the country illegally and was found dead on George Kelly's property. Now, Kelly has pled not guilty, saying that he only fired warning shots. Now, the governor of the great state of Arizona has said that she would veto a bill approved by any Arizona lawmakers that would allow state police to arrest people who enter the country illegally. And the bill is similar to the one in Texas that was scheduled to go into effect next month, but was blocked by a federal court. Now, the case of George Kelly, we've been bringing it to you, but we're uncertain if there was a feed issue or whatever, but no video today. Now, Wanda Kelly, the wife of rancher George Kelly, was supposed to take the stand today, and she testified on day 7 of the trial, and she detailed the events leading up to the discovery of the victim's body on January 30th. She testified that her husband told her to call Border Patrol after he thought he heard gunshots. Wanda Kelly said that she saw 2 men with rifles while looking through the window. That's when George went outside with his own rifle before she heard gunfire. So we shall see. Obviously, you have a right to defend yourself, even in Arizona, but it has to be an imminent threat. And when somebody is a great distance away from you, That's going to be the legal question here, ladies and gentlemen. I think we all have opinions on this, but guess what? Oftentimes our opinions don't always conform to the law, and that's what the jury is going to have to do, to follow the law. All right, remember Jennifer Crumbly? That's right, the mother of the Michigan school shooter, Ethan Crumbly. Guess where she wants to live if she does not get jail time? As you may recall, she was convicted of involuntary manslaughter, and she is asking to be sentenced to house arrest. Okay, that seems reasonable, right? House arrest, that's good. Where does she want this house arrest to be? At her lawyer's guest house, in the house where her lawyer lives. That's right. Now, Ms. Crumbly is looking up to 15 years in prison after being convicted in the landmark and unique legal case that found that she ignored numerous warning signs that her son might carry out a school shooting. Now, her lawyer, Shannon Smith, has requested that Jennifer Crumbly live in her guest house, which prosecutors say is an upgrade on her current house at her home in northern Oakland County there in Michigan. Guess what? The prosecutor says the prison sentence needs to be served in prison. The prosecutor there, Mark Case, said the request for the lenient living conditions is a slap in the face to the severity of the tragedy caused by the defendant's gross negligence. Instead, the prosecutor has recommended a 10 to 15-year prison sentence for both Jennifer and her husband, James, who was also found guilty of involuntary manslaughter. They are both scheduled to be sentenced on next Tuesday. And like Jennifer, James is seeking to avoid prison and has asked for time served instead of any further sentence. Now, as you may recall, the prosecutors argued that the Crumblys were so negligent as a parent that they were both partly to blame for their son Ethan, who was then 15, who killed 4 people and injured 7 more at the Oxford High School in Pontiac, Michigan on November of 2021. Now, the jury heard that the Crumblys were more interested in their extramarital affair, or at least Jennifer's, their horses, and going out on the town in the evenings rather than spending quality time with their son. Now, the 45-year-old Jennifer and her husband, James, allegedly bought the gun for their son used in the shooting just 4 days before the massacre. Now, prosecutors put forward this novel theory, and I say novel because it is, of extended parental liability, which the jury agreed with and found them both guilty after about 11 hours of deliberations. I've said this before, and I will say it again. I think it's a slippery slope. And one of our moderators, Mama Pink, sent me an article just the other day of a teen who had had several driving incidents where somebody was injured or killed, and now they want to go after the parents. How could the parents continue to let this poor driver drive after he's had 2 accidents, pay the insurance? Obviously, they don't care. They're not good parents, and therefore they should be charged criminally. Be careful what you wish for, ladies and gentlemen. It could be you or one of the family members that you know. Can you imagine making bad parenting a crime? Ought to be good for defense attorneys, because I see a lot of bad parenting going on out there. Anyway, as it relates to the Crumblys, the prosecutors alleged that they failed to secure the gun properly, and Ethan then went on his rampage after going to the practice range. We'll see. I think that's just a bad case. I get it. It's a tragedy. The emotion of it, I get it. The jurors see all the pictures of the dead kids in the school. It's emotional. By God, someone should pay. How could you let this happen? You're a bad parent. I'm a good parent. I would never let this happen. Just saying. It's bad law. Bad law. I hope the appellate courts reverse it. Not because I think the good Crumblys are good parents. I don't. But I think it's a very dangerous, slippery slope, ladies and gentlemen. Next, should we be able to sue prosecutors? That's right. We're obviously a litigious society here in America, but there are some group of people called prosecutors that, you can't sue, even if they wrong you. And one of those, like I said, is is the prosecutors, and despite their power over justice and injustice for thousands of years, prosecutors are usually immune from federal civil rights lawsuit. Well, the Supreme Court may soon decide whether to hear a case that could roll back prosecutors' absolute immunity after, well, criticism and skepticism about the scope of that governmental immunity. The case is called Price v. Montgomery County, and it comes from a situation that took place in Kentucky. So back in 2018, Nikki Miller sued a group of state law enforcement officials in federal court for allegedly conspiring to frame him for the murder of a guy by the name of Paul Brewer. Now, the brother of a former state trooper who had been found tied to his bed and shot to death 7 years earlier. 4 years of investigation by the police failed to surface a suspect in the killing. But that all changed when the officers received tips from a jailhouse informant that led them to a woman named Natasha Martin. Now, during a police investigation, she claimed that she, Miller, and a few others had taken part in the murder, with Miller firing the fatal gunshot. Now, Miller was jailed for 2 years before prosecutors eventually dropped the charges against him. Now, a key part of the lawsuit centers on the actions of Keith Craycraft, an assistant state prosecutor. Now, both sides of the lawsuit agree that Martin almost immediately sought to retract her confession. She also wrote letters while in jail that recanted her confession, which she said had been extracted through coercive means. A Kentucky court ordered the jail to turn over the letters at the request of Miller's lawyers. Well, after the court orders came down, Craycraft, the attorney, spoke with Martin by phone. The two sides disagree on exactly what happened next. Miller's estate, he died while midway through the litigation, alleged that Craycraft instructed Martin to destroy the exculpatory letters. Anyway, so Craycraft said in a deposition that he simply advised Martin to contact her own lawyer for further advice. In any event, the letters, well, guess what? They disappeared. Oops, kind of like videotapes. Funny how that works, isn't it? Anyway, Miller's original lawsuit alleged a broader conspiracy within the Kentucky law enforcement apparatus, but the legal issue in the state's petition for the Supreme Court are a little more narrow. So after the lawsuit was filed, Craycraft moved to dismiss on the basis that, hey, as a prosecutor, I have prosecutorial immunity. And he argued that Section 1983, the federal law invoked by Miller for his complaint, did not allow lawsuits against him for the actions that he allegedly committed while he was a prosecutor. Well, a federal district court judge in Kentucky agreed, as did the Sixth Circuit Court of Appeals. And they say that the plaintiff's facts, even if true, when decided, motions to dismiss, so the rulings operated from the assumption that Craycraft did tell Martin to destroy the evidence, right? Every civil case, the court can't just say that's hogwash because the defendant said it was hogwash. You have to treat the allegations as true. But the court said even if I take those allegations as true, he's entitled to immunity for allegedly destroying the evidence, despite the court order not to do so. Anyway, the behavior Miller describes in his complaint is difficult to justify of an official entrusted with enforcing criminal law, the Sixth Circuit said, and the majority noted as an understatement, at the same time Craycraft has met his burden of establishing that the conduct at issue was committed in his role as a prosecutor, rendering him immune from suit. Okay. So how did this all come about? Well, in 1871, Congress passed the Enforcement Act to address deprivations of rights in the post-war American South. One of the provisions, now known as Section 1983, allows people to sue state and local officials in federal court for violating their federal constitutional rights. Now, the courts have recognized various forms of legal immunity from Section 1983 lawsuits over the years. Most states and local officials enjoy what is known as qualified immunity in the sense that they enjoy the immunity with some qualifications. Generally speaking, those officials can't be sued unless they violate a clearly established constitutional right. Three groups of officials, though, judges, legislators, and prosecutors, well, they have absolute immunity, meaning they can't be sued for their official acts. The Supreme Court revived Section 1983 in the mid-20th century and the justices also began to outline limits to its scope. The first declared that prosecutors enjoy absolute immunity under Section 1983, as they decided in a case back in 1976. That case centered on a former death row inmate in California who had been exonerated based on evidence that he believed had been withheld by the prosecutors in his trial. In an 8-0 decision, the court rejected the lawsuit. It argued that prosecutors enjoyed a form of absolute immunity that derived from judicial immunity. The common law immunity of a prosecutor is based on the same consideration that underlies the common law immunity for judges and grand jurors acting within the scope of their duties, the Supreme Court wrote. And the Supreme Court also emphasized that they saw a practical concern with allowing Section 1983 claims against prosecutors. They were concerned that they would be filed for harassment purposes, and there'd be unfounded litigation that would cause a deflection of the prosecutor's energies from his public duties, and the possibility that that would shade his decision instead of exercising independent judgment required by his public trust. So, in this petition that's up before the United States Supreme Court, the Supreme Court hasn't decided whether they're going to take it just yet, but Miller argued that the justices should take it up because the lower courts are divided on how absolute immunity applies in these cases. Some of the federal appeals courts have held that the destruction of evidence falls under prosecutors' discretion regarding what to present to a jury. The Third Circuit, on the other hand, has said that destroying exculpatory evidence does not fall within the prosecutor's duties and therefore is not entitled to immunity. The Sixth Circuit, ruling against Miller, expanded that split in the lower courts, and while the Supreme Court is generally free to take up cases for whatever reason it chooses, it often takes them up to address divides in the federal circuits. Now, while the Kentucky Solicitor General's office claims in a filing that there was no circuit split, it's more of less conceded that one exists in actual argument. So the real question is should prosecutors get absolute immunity from being sued when they destroy evidence? What is the interest of justice does that serve, ladies and gentlemen? Just something to think about. Next, a National Guardsman turns around at a checkpoint. What did he have to be concerned about? I don't know. So a Texas National Guardsman is accused of smuggling a migrant across the border into Texas while being deployed to stop asylum seekers entering the United States, and his arrest was captured on video. Take a look at this. Specialist Donovan Johnson was arrested on Sunday afternoon after a high-speed chase with the police there in Texas. The Texas Department of Public Safety and the Keeney County Sheriff's deputies pursued him after he abruptly turned around ahead of a checkpoint. His sudden course change was suspicious, and guess what? The chase was on. Speeds reached up to 100 miles an hour. Now, the sheriff confirmed that Mr. Johnson was a member of the Texas National Guard, obviously there to prevent border crossings at the Eagle Pass crossing. And the body cam footage shows Mr. Johnson, or Specialist Johnson, being hauled out of his GMC truck after road spikes finally flattened his tires. Now, police discovered he was from the National Guard when they were going through his belongings, and they found his ID card. Not good. Anyway, Johnson, he lives in San Antonio and was allegedly paid up to $6,000 to take the man over the border undetected. The man was allegedly transporting, later surrendered to authorities at a crossing guard. Needless to say, the governor, who's responsible for the National Guard there in Texas, was not happy and said Johnson, basically, if these allegations are true, he is a traitor and a criminal. We have zero tolerance for Texans who violate laws that directly contradict the mission we seek to achieve, the governor said, and the accused illegal smuggling may subject him to mandatory prison sentences of up to 10 years. Just something to think about, ladies and gentlemen. If you're in the National Guard, don't smuggle asylum seekers across the border, even if they pay you $6,000. Very lucrative, I hear. Please Go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Anyway, next on the docket, please meet Mr. Peter Owens. He went to a Walgreens on Sunday evening to purchase some headphones. While at the Clearwater, Florida Walgreens, Mr. Owens got into a verbal altercation with one of the employees over the headphones. Not exactly sure, but when Nicole Merck, the store manager, approached Mr. Owens to ask him to leave the Walgreens, Peter used his Bible that he had in his hand and struck Nicole in the face and then exited the store. Now, after the alleged Bible battery, the police located Mr. Owens and took him into custody. And they advised him of his Miranda rights because he was in custody and being interrogated. We know that because we follow Crime Talk. And Mr. Owens then admitted to striking Nicole Merck in the face one time with the Bible because she was being rude to him. Well, Peter stated he really didn't mean to hit her, but, if he did, he didn't, hit her hard. Anyway, Mr. Peter Owens was charged with an enhancement for a felony because he had a conviction back in Michigan in 2020 for, guess what, an assault and battery in which he had a year's probation. Anyway, Mr. Owens was released from the county jail after posting a $5,000 bond. The judge has ordered him to have no contact with Ms. Merck, and he has to stay away from that particular Walgreens. Now, Mr. Owens works as a golf instructor, and he now lives in Sarasota, Florida. Guess he could not recall the reference in the Bible of turn the other cheek. So I had to look it up. It's Matthew 5:38 and 39. You have heard that it was said, eye for an eye and a tooth for a tooth. But I tell you, do not resist an evil person. If anyone slaps you on the right cheek, turn to them the other cheek also. There you go, ladies and gentlemen. There you go. Anyway, thanks for watching. Have a wonderful day, and we'll see you next time on Crime Talk.